That's true, my lord.
And Richard for A1 and A2, Amapa Karua Senior Council, together with areas of Wago, Proscovia Kunihira, Ivan Bowe,
Ivan Bowe,
Katotu Musime, and Kakuru Tumusime.
There are two persons. Count 1 is prison. Count 2 is prison of prison. Count 3 is prison of prison. All under penalty of death. The two persons were charged in Nakawa Chief Magistrate's Court on the 21st February 2025. From court report of the lower court, the accused persons were committed to High Court on 29th May 2025. Thereafter, from the lower court file, that is file number 8 of 2025, the file was forwarded to criminal division on ICMIS on 27th June 2025. From the record of criminal division, the matter was eventually allocated to a trial judge on 2nd of July. When the matter came up for scheduling and pre-taking on 8th October, A1 was given an opportunity to raise his concerns orally in open court. And from his concerns raised, he raised two issues for court's determination. The two issues captured by this honorable court, number one, that this court has no jurisdiction and that the file should be transferred to ICT. Two, that the trial judge is incompetent or biased based on the ruling made in the application for mandatory bail, and hence the trial judge should recuse himself from hearing this matter. Briefly, those were the issues raised by one. S3 raised an issue of his identity. I proceed to consider the submissions made by the accused persons themselves. In summary, A1 challenged the court's jurisdiction, asserting that Nakawa Chief Magistrate's Court committed the accused to ICD on May 29th, 2025, not criminal division. A1 wondered why they were in criminal division. He submitted that this was a deliberate to prolong their detention. The accused further stated that they have since filed a formal complaint to the Judicial Service Commission seeking the removal of the trial judge from the office of the judge. A1 prayed that original file number 8 of 2025 from Nakawa, which is now session number 335 of 2025, transferred to International Crimes Division. Issue number 2, that the trial judge is incompetent or biased, basing on the ruling made in application for mandatory bail, and hence the trial judge should recuse himself. A1 submitted that the trial judge is incompetent or biased, and A1 based on his grievances on the ruling of mandatory bail, where the trial judge did not deny him an A2 mandatory bail. He submitted that the trial judge ignored political documents relating to their illegal detention in general court martial. He requested that the trial judge recuse himself from handling the matter. Issue number 3 raised by S3 relating to identity. S3 submitted that the person charged in the indictment is different from him, that even if they share the same force number and same rank, the names and the age are different. S3 went ahead to state his proper identity. He prayed that the charges be dismissed against him. Now go to the reply by the state on issue 1, 2, and 3. In reply, Mr. Dirivumbu, Chief State Attorney, submitted that wording in notes to accused persons attached to the indictment, stating that, I quote, that the accused persons will be tried at the session at ICD was a typo error, and it was supposed to read at High Court of Uganda at Kampala. He further submitted that prosecution had taken note of the error, and prosecution was waiting for an opportune time when the accused person are ready to take plea, and he would make an application of indictment amended under section 51 of TIA. The Chief State Attorney submitted that ICD is a specialized division designed to handle cases of international crimes, among others, but not treason. He submitted that the charges the accused are indicted with fall under the jurisdiction of criminal division. He prayed that the matter continues at criminal division, and there is no reason to warrant a transfer to ICD since the file is properly forwarded. In his reply on the issue of alleged incompetence and bias, incompetence or bias, the state stated that prosecution has not detected any sign of incompetence or bias on the side of the trial judge. He further submitted that the alleged petition against the trial judge at the Judicial Service Commission is not a bar for a judge to handle this matter, which was properly allocated to him. He stated that in any case, the Judicial Service Commission has not brought the petition to the knowledge of the trial judge to stop him from handling the matter. In reply to the issue of identity raised by S3, the state attorney submitted that the issue can be dealt with by making an application for amendment to cure the issue of identity. In rejoinder, the lawyers of the accused persons made submissions on behalf of the accused persons, stating that the prosecution had raised issues of law that needed to be addressed by advocates. I have put into consideration all their submissions, which are on court record. But briefly, I will summarize their submissions in rejoinder on behalf of the accused persons. Issue number one, they are rejoined on issue number one. This court and that the file should be transferred to ICT. The council submitted that there is an order of committal from Nakawa Chief Magistrate Court forwarding the file to ICT, but the file was snatched and brought to criminal division. That the order of committal was for ICD, and the question is, how did this file come to criminal division? Council submitted that divisions are different, and the processes, procedures, composition of ICD differ from that one of criminal division. Council contended that this court is acting illegally by entertaining the matter, since criminal division has no jurisdiction to do so. Council stressed that the indictment from Nakawa court was very clear that the accused were to be tried at a session at ICT. That it is not right for the prosecution to state that there was a typing error. Council admitted further that the offenses of treason against the accused persons were committed cross-border, and since ICD has a jurisdiction to try cross-border crimes, the accused persons should be tried on ICD. In regard to incompetence or bias, council submitted that fairness is an issue of perception in the mind of a reasonable man. That justice must not only be done, but must also be seen to be done. Council submitted that the accused persons made a complaint to Judicial Service Commission for removal of the trial judge from office. Hence, the trial judge did not continue handling the matter. Further, council also referred to the ruling in the application for mandatory bail, where this honorable court declined to grant A1 and A2 mandatory bail. Yet, in their view, they had provided for mandatory bail and stated that this amounted to incompetence or bias, which compromises the accused's right to fair trial. In rejoinder by counsel for S3, counsel for S3 submitted that the issue of identity was raised in the lower court, but the same was ignored. Counsel referred to the case of Yasin Juma versus Republic, where Court of Appeal quashed the decision of the lower court based on the failure to properly identify the accused person. Counsel prayed that this court be pleased to strike S3 of the indictment and order for the immediate release. I will now proceed to the determination of court on issue 1, 2, and 3. Issue number 1, that this court has no jurisdiction and that the file should be transferred to ICT. I have had the opportunity to scrutinize the entire lower court record of criminal case number 8 of 2025 from Nakawa Chief Magistrate's Court. This case number 8 of 2025 is now session number 335 of 2025. I have also looked at the history of this matter even before committal. Upon looking at the history of this matter, there are various applications arising from the same case, that is case number 8 of 2025. A1 and A2 filed criminal application number 113 of 2025. This application for bail was arising from Nakawa Chief Magistrate's Court, case number 8 of 2025. This This application was filed on 27th February 2025, when personally, as a trial judge, I had not been transferred even in criminal division. This application for bail in criminal division was handled and disposed of by my sister judge, Justice Comfort Kanye, on 11th April 2025, when the trial judge was not yet in this division. A1 and A2 further filed another application for bail. This is bail miscellaneous application number 282 of 2025. This application for bail was filed on 22nd April 2025. This bail application also arises from the same case of Nakawa, number 8 of 2025. This application equally was filed in the criminal division, and this application for bail is still pending before this honorable court. The accused person, A1 and A2, still, I noticed that they filed an application for revision in the criminal division. This case for revision was arising from the proceedings of Nakawa Court, the same criminal case 8 of 2025. This case for revision has since been withdrawn from criminal division. A1 and A2 went ahead and filed the miscellaneous application number 399 of 2025. It was filed on 28th May 2025. This was an application for mandatory bail. This application was equally filed in criminal division. It was heard and disposed of by this honorable court in this division. All these applications, my view, filed in the criminal division show that the accused persons and their lawyers knew that this was the right court or right division with jurisdiction to grant bail. And all these applications on their own voluntary chosen and counsel, they filed these applications arising from this criminal case of Nakawa, number 8 of 2025, now session number 335 of 2025. In addition to the above finding, I have very carefully looked at the committal proceedings in Nakawa Chief Magistrate's Court. Upon perusal of the lower court record of Nakawa, that is case number 8 of 2025, when the Chief Magistrate Nakawa was committing the accused persons on 29th May, court stated, I quote from the proceedings, that in the indictment and summary of the case is read to the accused persons, and the accused persons are hereby committed by court for trial. In my view, criminal division is a division of high court. It is also my view that criminal division has jurisdiction to handle cases of this nature. The lower court record also shows that criminal case number 8 of 2025 was forwarded on ICMIS on 27th June. And when this file was forwarded on ICMIS on 27th June, the file was officially allocated to the trial judge on 2nd July. Further, the Chief Magistrate Nakawa, according to the court record, the Chief Magistrate Nakawa wrote a forwarding letter to the Deputy Registrar Criminal Division. This letter is dated 15th July. It is available on court record. This physical letter was forwarding the physical file number 8 of 2025 Criminal Division. All these developments show that criminal case number 8 of 2025 now session number 335 of 2025, was properly forwarded to criminal division after committal. This court is not aware of any registration number of the same case at the registry of ICD. Or court is also not aware of any other forwarding letter from the lower court to the registry of ICD. This has been claimed by accused and their lawyer to suggest that there are other documents forwarding the file to ICD. But if any, there is no document that was provided to this honorable court show that the same case number had been forwarded to ICD and registered to ICD. Also to mention that the accused persons are charged with offenses of treason and misprision of treason. This division, criminal division, has jurisdiction to try the same and has been handling other similar cases in the division. It was my considered view that the turnaround by the accused persons to allege that criminal division of the High Court hijacked the file from ICD and of which it lacks jurisdiction to try this matter is a mere afterthought and a deliberate move which I cannot at this stage tell the reason. So in the view of the bar, I found that this file number 8 of 2025, now session number 335 of 2025, and the accused persons are properly before the right court. I will now go to the issue of the trial that the trial judges promise he should recuse from the trial. I will proceed to consider the issue of incompetency and bias and subsequent request for recusal by accused persons. I have looked at the grounds for recusal in the practice directions and put them down. I have looked at other authorities for recusal and the tests in those cases, the same are provided here. But I will now proceed to this instant case. The basis for allegations of incompetency or bias stems from the ruling in an application for mandatory bail. That was application number 399 of 2025, where it is alleged that court ignored political documents in relation to A1 and A2's illegal detention in the general court martial and denied the mandatory bail to the accused persons. It is my considered view that the application for mandatory bail, which was referred to, was considered on its own merit, based on the facts and the law relating to mandatory bail. The accused persons cannot use the decision of the court for denial of mandatory bail to impute incompetence or bias on the side of the judge. In any case, throughout my practice as a judicial officer, a court can deny bail today on circumstances at the time, but grant bail at any stage at a later stage. So, denial of bail, the first trial of denial of bail, doesn't mean incompetency or bias or that the judge will never grant bail. It is not proper for litigants to use decisions which are not in their favor to make false allegations of incompetence and bias. Where parties get decisions that are not in their favor, like it was in the application for mandatory bail, the remedy and procedure of challenging such decisions are provided for under the law. But it's not fair to hide under allegations of incompetence or bias. The accused person's father claimed that they made a complaint against the trial judge in the Judicial Service Commission, petitioning his removal from office. It is my view that the said complaint lodged with Judicial Service Commission is not a bar or a stage of proceedings or cannot be used for recusal. Whoever wants to prevent a judicial officer from hearing a certain case would simply lodge a complaint with the Judicial Service Commission, which will cause absurdity. I do not find any ground for recusal based on allegations of incompetence or bias. It should be noted that this court is a temple of justice, which upholds the constitutional principles of fair trial and natural justice as provided for under Article 28 of the Constitution. There is no way whatsoever this court can bypass the constitutional provisions and undermine the rights of the accused persons to fair trial. This fair trial indeed is submitted by the lawyers. It is provided under the Constitution, and this court is supposed to uphold such a provision. I will now go to issue number 3, which was raised by S3. This is an issue of identity. That he is not the person indicting. That though they have the same post number and rank, the names and age are different. It is my view that this issue can be sorted out during scheduling before pre-taking, but not at this stage of many applications. In the final result, this court makes the following orders. 1. The application by the accused persons to transfer the file of IC